Supreme Court of Florida is now in session. The Honorable Chief Justice Charles T. Kennedy presiding.
Good morning and welcome to this remote session of the Florida Supreme Court. We will now take up the case of Suarez Trucking versus Souders. Counsel?
May it please the court. My name is Kansas Gooden. I represent Suarez Trucking. I like to reserve 4 minutes for rebuttal. A settlement was reached in this case when Suarez Trucking filed a written notice of acceptance in the trial court. Florida Statute 76879 states, an offer shall be accepted by filing a written notice of acceptance with the court within 30 days after service. The legislature mandated how a proposal for settlement is accepted. And when a legislature prescribes the mode, that mode must be observed. And it essentially is a prohibition of it being done any other way. And this statute simply requires a written acceptance, nothing more. It doesn't require, despite what the Second DCA held, that the parties parrot back each and every term of the proposal for settlement. It simply has to say, I accept.
Counsel, I'm sorry to interrupt.
Counsel, if I could ask you this, Counsel. Now, there's really no suggestion that the parties who wish to settle a case have to operate under this statute. If they just want to settle it and without reference to the statute, they don't get the benefit of the statute, but they are not precluded from doing that. But if they want the benefit of the statute, they have to operate under the statute. Isn't that correct?
100%, Your Honor. And Souders made that deliberate decision here to operate under the statute.
Can I ask you a question? So part of this case has to do with the acceptance issue, but then the other part of it has to do with, even if we agree with you that there was an acceptance of some kind, whether the agreement was breached. And with regard to that second issue, what is the legal significance of the fact that before the acceptance and before sending the check, that apparently counsel for each side communicated directly on this issue of satisfying the lien, and that on the plaintiff side, it was clearly communicated that that was not acceptable, that the check had to be just made out to the plaintiff alone? Does that have any legal relevance here? No.
And if you turn to actually Rule 1.442, it states that oral communications do not constitute a counteroffer. It doesn't constitute a rejection whatsoever. What was happening here is just trying to seek clarification, because the defense was in a catch-22. This was a valid known lien that they just wanted to make sure was taken care of. And if you do look at the record, there were disputed statements regarding exactly what happened. Suarez Trucking takes the position that that conversation was, will you make assurances that this lien will be taken care of? And the plaintiff's attorney at the time said, no, I'm not going to give you assurances. And those assurances came later. The plaintiff's attorney at the hearing, I believe, said, well, this was about a release. They were asking about a release. So there were disputed statements below regarding those conversations. But ultimately, I don't think those disputed statements really go one way or the other, because I think the issue is truly a legal issue. And it kind of goes back. Though?
And so what's the legal issue as you see it on the breach question?
On the breach, kind of what's the remedy? And if you
hold on, before we get to the remedy, though, if we read the proposal for settlement, and we see where it says the defendants shall pay $500,000 to the plaintiff within 10 days from the date of acceptance. If we read that as on its face requiring payment to the plaintiff and not to anyone else, do you lose?
No.
Okay, why not?
We do not, because the statute controls, and we have a valid settlement agreement. And so that's when we would get remanded for a judgment of $500,000. And then there would be a further determination of whatever this work comp lien is. And the support,
I think you face another catch-22, to use a phrase you used. So let's say we agree with you, the statute controls and it should influence, what we think constitutes an acceptance in this case. Don't we then lose jurisdiction because in Marin versus Infinity Auto, the statute wasn't at issue, and it's not a case governed under the same provision, and so if you're right, then we don't even have a conflict to resolve.
well, there's two different conflict cases here before the court. The first one is Cirrus Design
Let's
specifically.
assume for the sake of argument that we don't think there's a conflict with Cirrus. Focus on Marin.
So Marin, I do believe there is a express and direct conflict, even though it's not traveling under the PFS statute. It regards to how, especially whether that lien holder should be required on the check and whether that's an essential term. And if you look at the opinions in both cases, they came out differently. The second DCA said, yes, that was an essential term. The third DCA said it wasn't.
Right, I know, but my question is to the fact that Marin, the statute's not at issue in Marin, right? We agree on
Correct.
that.
Yes.
Okay. So help me out with the catch-22, or are you just sort of admitting that there is, in fact, this like weird catch-22?
There is a weird catch-22, but it's mostly, and it's the mechanics of the lien is how the lien was playing out. And I think the catch-22 is more in the situation of the defense was in a bad situation of knowing whether or not this lien was going to be taken care of. And that's where the Marin case comes into play. Now, I know you said don't take Cirrus into account, but if we do take Cirrus into account, there is conflict jurisdiction. And once this court has jurisdiction, it has authority to address all issues in a case. And that's when you can kind of flow down and deal with the remedy and everything with kind of everything that flows from this.
Counsel, you keep talking about remedy, but now I understand if there was a breach, you think the remedy is to enforce the settlement agreement as opposed to rescind the settlement agreement. Okay, that's your position. But isn't it your basic position that there was not a breach?
Correct. We do not believe there was a breach. And this is just based on the plain language of this proposal for settlement. Because the language says shall pay $500,000 to the plaintiff. And just plain language, that does not say a check shall be made payable to. It doesn't direct how the check.
But doesn't your argument also, I understand you've articulated that, but doesn't your argument really more turn on the fact that part of the backdrop for this whole situation is not just the offer of judgment statute, but the statute that governs workers' compensation liens. The statute that provides that when the plaintiff here brought the lawsuit, that by operation of law, the plaintiff was bringing the lawsuit not only for the plaintiff, but for the use and benefit of the carrier.
Correct,
And
Honor.
all of that, and the law that says that these funds can't be dispersed until the allocation between the carrier and the plaintiff is worked out either by agreement or by determination of court. That's all part of the backdrop for this that informs your argument. Isn't that correct?
That is correct. And if you go back to Circle K.
Can I ask you, I'm sorry, counsel, I'm sorry to interrupt you.
Would you let her answer my question?
Oh, I'm sorry. She did answer your question.
I'm sorry.
If you go back to Circle K, it even says that the work comp carrier has to consent. And the same with Century Elevator talks about how that lien holder actually has to participate in the settlement. And that is all under the guise of the work comp statute.
Justice Moody?
So I'm that on that background law issue, is it your position though that what if it seems like part of your argument here is that you're kind of ignoring the negative implication of, pay me $500,000. And you're saying that on its face, that doesn't preclude the possibility of adding other people to the check. So let's put that aside for 1 minute. But if we have this argument about the supposed background law, what if the settlement had said explicitly write me and only me a check for $500,000. Is it your position that that would be sort of a legally not permissible offer? I mean, help me understand what work you think the background law is doing here.
Well, under that scenario, I still think we would have a settlement agreement. And that's just going back to the plain wording of the statute. The moment that that notice of acceptance was filed, there's a settlement agreement. And that's just plain language of that statute. Where that language comes in that you just referenced comes into how it's enforced. And specifically, that would have to go to, again, the performance of the proposal for settlement at that point. And the fourth DCA has been kind of clear for almost 20 years now that when you're dealing with a situation under the proposal for settlement statute, you don't have to have the ability to pay. If you don't have the ability to pay, what happens is a judgment is entered. And so a judgment for $500,000 should have been entered at that point. It shouldn't have been defined that the acceptance that was filed was null and void. And that's what the trial court did. And that's where the case really went awry at that point.
But doesn't Suarez itself say, though, that as with any other contract, one of the remedies for a breach of a settlement agreement is rescission? I mean, why should in this context, if you in the scenario that we gave where there's no doubt whatsoever that the offer said, I only want my name on the check, and then that's quote unquote accepted, and then 10 days later the check comes through and it has multiple names on the check. You agree that in that case there's a breach. You're saying that the only remedy is you've got to basically force the entity to write a new check with only one name on it. But I mean, isn't it just basic contract law that the plaintiff would have the option of either that remedy or rescinding the contract? I mean, that's what Suarez says in the footnote 4.
Correct. Suarez does say that in footnote 4. However, the parties actually have to plead that. In this case, the parties never pled rescission. Souders never said, we have a contract, let's rescind it. It was, we never had a contract. And those are two different things. To get to rescission, you have to admit there's a contract, and they never did that here.
So would that then go to, would essentially, and this is part of this whole issue with the jurisdiction, is just speaking for myself, I'm kind of wondering kind of what the point of all this is, because it seems like, you know, I could see us saying, look, there's a conflict on whether there was really an acceptance of a contract, and we're going to resolve that and say that there was an acceptance, but there's no conflict on the sort of breach, and if so, how you remedy issue. If we were to send it back and say, okay, assume there was a contract, now you proceed under that assumption, and then the plaintiff says, we want to rescind, then we're right back in the same place. I mean, I don't know that there's any authority for us to say that rescission at that point would not be an available option, that is just off the table. So could you give me authority that takes that off the table on remand?
Well, on remand, and again, rescission has never been alleged and never been assault by Souders. The fact that it's being brought up now at the Florida Supreme Court, it seems, honestly, it's coming out of left field, because that, again, the remand would have to be what was before this court. And if you look at Suarez, and if you look at Suarez Trucking, and in Suarez, they enforced that settlement. And so when you're dealing with a conflict, let's take en banc procedures out of this. When you're dealing with conflict, if you have one case that essentially would be overruling the other case if they were issued by the same court, that's a conflict. And if you read Suarez Trucking, and if you read Suarez Design, that's what we have here. And so if you accept and approve Suarez Design, the remedy is enforcing this contract. It is not allowing them a second bite of the apple to try to rescind this contract. It is instead enforcing it.
And counsel, let me ask you about footnote 4. This has been mentioned. It says, although Suarez does not make the argument the logical extension of Cirrus' position is that rescission of the settlement contract is a possible remedy the plaintiffs may pursue. Whatever that is, isn't it dicta?
100%. It is dicta, and it's, again, it's the same situation we have here. Souders never pursued rescission. And I think a lot of it has to go with, they never admitted there was a contract in the first instance. From day one, they took the position there was no contract. And so I think that's really, our case is in direct, express and direct conflict with Cirrus Design.
Counsel, though, are you disputing though the premise that the plaintiff, I mean, are you hinging it on this sort of waiver thing? I mean, where obviously they're not going to argue rescission if they're saying there's no contract to begin with, but just to get back to what the chief is asking you, dicta or not, are you disputing the legal premise that the plaintiff would take waiver off the table for a second? In a case, let's say that, could they have argued at the beginning, trial court, hey, we think there's no contract, and even if there is, there was a breach and we choose as a remedy rescission? Are you telling me that legally would have not been a permissible request, a valid option for the plaintiff?
The plaintiff could have pled that, and it could have pled that in the alternative. You could have admitted the existence of a contract and not the existence. You're allowed to make alternative arguments, but that never happened here. Okay. And so and again, this is why we are directly in conflict with Cirrus. It was never alleged in this case. It wasn't alleged in Cirrus. Rescission is an option when you're dealing with contract cases, but it has to be alleged. And for now, all of a sudden, to be alleged.
Isn't it also true, counsel, that rescission is not always an option for every breach? It depends on the type of contract, and if it's a substituted, there's certainly, isn't there authority that if it's a substituted contract, that there are at least some circumstances where rescission is not available for every breach?
I believe so, Your Honor.
Mm-hmm. All right, counsel, I have helped you use that part of your rebuttal time. You can keep going, but you're using it.
I'll reserve the rest of my time. Thank you, Your Honor.
Thank you. Counsel.
Good morning. May it please the court. My name is Joel Eaton, and I represent the respondent, who is the plaintiff below, Adam Souders. I would like to begin by establishing three undebatable propositions of the law of contracts here. It'll be very brief. Assume this offer was made prior to filing suit. It plainly would have been an offer to enter into a unilateral contract. A unilateral contract can only be accepted by performance, and the performance.
I understand you want to repeat your tutorial on the law of contract for us here. We appreciate having the benefit of that. We're much obliged for it in the brief. But let me ask you this: when I look at what actually happened here, not some hypothetical, it seems that the actual offer that was made invited a promissory acceptance. Why am I wrong about that?
I'm reluctant, Mr. Chief Justice, to say you're wrong about anything, but there is an answer to your question. The offer that was made was not simply for an acceptance with a notice of acceptance. The offer very clearly read, upon acceptance and payment of the proposal for settlement, will dismiss the lawsuit. So,
well, I understand that, parties always contemplate that there's going to be performance when they get a promise to perform. They contemplate that ultimately there will be performance, but that doesn't mean that every contract is a unilateral contract.
Well, my point was, and I'll make it simpler, under the law of contracts, there was clearly no performance. There was a mirror image. And therefore, under the law of contracts, there was clearly no settlement agreement. settlement agreements are governed by the law of contracts. That's
Well, but
Robert
here,
versus City of
but-
Miami.
yeah, but Mr. Eaton, this is a great, discussion in a vacuum, but here you do have a statute, right? I mean, you don't dispute that we're operating under the offer of judgment statute, and that statute alters a little bit these principles that we're discussing in a vacuum. How do you respond to Ms. Gooden's argument that under the statute, there really isn't anything on the face of the statute to require that Suarez Trucking do anything more to accept the offer? What's your answer to that?
I don't dispute that once suit was filed and then the offer to settle was made, the statute comes into play. But I think the statute is ambiguous, and that the legislature simply failed to consider the difference between a unilateral contract and a bilateral contract.
What's the ambiguity in the statute?
I think it's easy to read the statute to say, here's my notice of acceptance. I am accepting the unilateral contract as the common law of contracts requires. Now,
But counsel, I don't understand how you just get this idea that somehow the common law of contracts requires a unilateral contract. I mean, that depends to a large extent on the way the offer is framed, what the offer is. Now, if here, the way the offer is framed is dictated by this statute. But that's okay. That's your client chose to operate under that statute. Again, there's nothing that requires them to operate under this statute. They could settle outside the statute. They don't get the benefit of the statute if they do that. But if they want the benefit of the statute, it seems like they've got to accept the framework established by the statute. What am I missing?
well, there's no question but that the statute, the way Ms. Gooden wants you to read it, overturns and turns upside down nearly 100 years of contract law in this state. That's a pretty drastic way to read the legislative intent. And it's for that reason that I've relied on this court's decisions in Carlisle and Kitchen, which say, when we look at a statute, before we're going to say it overturns the common law, it has to be clear, unambiguous, and what's the three?
counsel-
But counsel,
counsel-
I don't follow how this is overturning the common law. Now we do know that in terms of the attorney's fee aspect of it, it does that is against the common law. That's a change in the common law. But you're not arguing against that. It just seems to me that the common law always has had, the common law for a while now has had bilateral contracts. And I don't understand how the legislature channeling this into the form of a bilateral contract overturns the common law. That's a category that's in the common law.
Well, to be frank with you, I don't think the legislature understood what it was doing. And
We know what they said. We can't delve into their understanding. We just got to look at what they said.
I understand what they said, but I think that what they said can reasonably be read to mean, I am accepting this contract by performing it as the law of contracts required. I am accepting, here's the notice, here's the check made payable to the plaintiff. It's done, everybody's happy.
I'm going to stop here. I just got another question that changes this a little bit, and then I'll stop. Or they focus on a little different aspect of this. Let me ask you this, counsel. Forget about how all this happened. This is a hypothetical. Say that this check was made out to the plaintiff and was sent to the plaintiff's lawyer. What would have happened to that check? How would the plaintiff's lawyer have handled that check? Could he give it to? Could the plaintiff's lawyer give it to the plaintiff and say, "Here, got your $500,000. Now, you know, there's a lien and they might come after you for that, but here, take it, you cash it, and we'll worry about the lien later. Would the law have done that?
I don't think that the fact that there was a lien in an undeterminable amount has a thing to do with the contract formation question.
I understand I appreciate that. And again, I'm much obliged to you for giving us your views on that, but I'd appreciate if you'd answer my question. I'd be more obliged if you'd answer my question.
Well, the check would be put in the attorney's trust account because there's a lien on it. And that's to be negotiated with the workers' comp carrier.
Okay, if that's the case, counsel, I don't understand how the rights of your client were in any respect materially affected by the way this check was made out when it was sent the first time.
The answer to that question is when you put the workers' comp carrier on a $500,000 check, when you may be able to negotiate a $200,000 payment to clear the lien, you have given the workers' comp carrier enormous leverage in the negotiation process. It can simply refuse to endorse the check.
I don't understand that, because they got the leverage anyway under the scenario you outlined. If they've got to agree, or it goes before a court before the money gets dispersed. Isn't that correct?
Yes.
Okay, so they've got that leverage. I don't understand how what's on the check is any more than just an immaterial circumstance.
Because under the law of contracts, it was not a mirror image acceptance of the proposal. That's the answer. I continue to think that the existence of that lien is irrelevant to the question of whether a contract was formed under the law of contracts. And I don't know how else to answer your question, but that let me get
counsel, are you finished answering the chief's question? Because I just wanted to ask you something.
Could you speak
are you finished answering the chief's question?
Yes.
Okay, so let's assume that there was a contract. Could you address the breach question? Let's assume there was a contract. I'm assuming your position would be that even if there was a contract, it was breached.
The position of the parties in their arguments below was the plaintiff said no contract. The defendant said, oh, we got a contract. That's all that happened below, and the trial court ruled that there was no contract. That when we came up through the second district, that was an argument, but the trucking company also argued that, okay, there's a contract, but maybe we breached it when we didn't comply with the terms of the proposal. And therefore, the remedy is to enter judgment on this contract that we breached in the amount of $500,000. In other words, although we breached the contract, give us the benefit of the contract, which doesn't make any logical sense to me. And our response, which was a reply to their argument, was no, 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 no. If you breached the contract, if there was a contract, as you say, and if you breached that contract by failing to perform with a mirror image of the proposal, then we are relieved of our obligation to dismiss the lawsuit. That's all we promised in this so-called bilateral contract. We promised that if you accepted and sent us a check in an amount of $500,000 with payment to the plaintiff, then we will dismiss the lawsuit. The law is perfectly clear and has been settled for a long time. And I quoted this court's decision in the Hospital Mortgage Group case, 1982, which says where a party breaches a contract, the other party is relieved of his obligation to perform his part of the contract. That's black letter Hornbook law. So once we didn't get the check that we had proposed to get, if there was a contract, a bilateral contract rather than a unilateral contract, they breached it. Our only obligation on the other side of that bilateral contract was to dismiss the lawsuit. We're relieved of that obligation by the defendant's breach. And
So I don't want to put words in your mouth, but I mean, does that make this kind of if you're right about that, then this whole thing is kind of an academic, this whole question about whether there was acceptance or not is, and under Chief Justice Kennedy's reading of what the offer was, that kind of takes the 768 completely out of the equation, because, one way to read this is that you made an offer that invited a promise in response. So you don't even have to worry about the statute, but you're still left with the breach question. And if you're right about both the breach and the remedy issue, then we're just sending it back just so that the court can refuse to enforce the contract for a different reason than the one that it gave.
well, I have always thought that Ms. Gooden's argument, with all due respect to her, and I do respect her, she's a very good lawyer, was sort of a Rube Goldberg contraption, which said, okay, we got a bilateral agreement in which we promised to fulfill your terms, which is send me a check for $500,000, and your only obligation is to dismiss the lawsuit. But they're saying I got to dismiss the lawsuit even though they didn't comply with our proposal, and we've got to pay them $500,000 judgment. They want the benefit of a contract that they breached, and I think that's the simple answer to this entire problem before the court, how to interpret 768-79. Certainly the statute, the rule could use a little tweaking to support my construction of the statute, but I don't think it's illogical to say, okay, I'll take Ms. Good's argument that there was an argument because we filed a mere notice of acceptance, but you breached the contract. You didn't comply with the terms of what you promised to do under this bilateral contract. And for that reason, the plaintiff is relieved of his obligation to dismiss the lawsuit. Case over. I have never thought that the court needed to get into the thicket of trying to figure out what the legislature intended when it wrote this statute. Now, the statute works perfectly well under my version of it in a case where a defendant makes a proposal for settlement, because requires an exchange of promises. But under an invitation to form a unilateral contract where performance is required, the statute purports to overturn 100 years of contract law in this state. And I don't believe this court is ready to do that. The simplest way to dispose of this case is to say, okay, we accept argumentatively that there was a contract, but if there was a contract, it was breached and the plaintiff didn't have to dismiss the lawsuit. No more questions. I've been arguing cases in this court for 45 years. This will be my last appearance before the court. I'm hanging up my tile and passing the torch to my younger compatriots. It has been an honor and a privilege to practice before this court, and I've enjoyed every minute of it. Thank you very much.
Well, thank you, Mr. Eaton. We wish you well in retirement, and I appreciate your service to the bar and your service to your clients. But we'll now go to rebuttal from opposing counsel.
Thank you,
Not
sir.
on that point, but on the case.
So with regards to, there was just an argument that this argument about breach somehow sprung up during the appeal in the second DCA, and that is not the case. If you look at the transcript, which is found in the record on 812 through 867, the trial attorney for Suarez Trucking specifically made this argument that any breach did not go to formation. It just went to, the check did not go to formation. It just went to breach. And if you take Mr. Eaton's argument, you have to ignore several cases specifically on the PFS statute, specifically Andre versus Myers and Abbott and Purdy. And in both of those cases, it says that the remedy, again, is by entering judgment. That is how you enforce a proposal for settlement in this context. There's no requirement under the statute that a party has to have the ability to pay a proposal for settlement that it accepts. And so
Counsel,
that,
did the defense tender a check that was payable only to the plaintiff after the other one was rejected?
no, they offered to have it reissued, and the plaintiff's attorney at that point said, no way, it's too late.
Was that still within 10 days of the acceptance?
I'm actually not sure. It was all right. It was a really tight time frame. I'm just not sure if it was in the 10 days or not.
Thank you.
The PFS statute does not work under Mr. Eaton's framework. And here's why. Because the entire purpose of proposals for settlement is to reduce litigation and settle cases. If you accept Souders' interpretation of this statute, you're actually going to be doing the opposite. Parties are going to be litigating whether or not there was an acceptance, just like they did in this case. There's going to be more litigation, and judicial labor is not going to end. And for that reason alone, we ask this court to reverse and remand for entry of final judgment for $500,000 against my client, and also to approve the conflict cases. And thank you everyone for your time.
All right. Well, we thank you both for your arguments in this case today. And again, Mr. Eaton, we wish you the very best in your retirement. And that will now conclude this session of the Florida Supreme Court.